I'm Allison Tate. I'm the director of Ada County Juvenile Services. And you've heard a lot today about the court system. What we really want to emphasize as we go through the process is how the juvenile system is different from what you've heard today. With regard to language access, you'll find that it's quite similar to what you've heard. So for instance, although we're in a different, smaller satellite courthouse, interpreters are provided by the same office for court, except, and I think someone pointed this out earlier, both the juvenile and the juvenile's parents would get an interpreter in our system. With regard to probation, and Lael can speak to this a little bit, we would also have an interpreter come work with the youth and parents. So the rights are much the same. So this is our org chart simplified. We have about 140 people. We have a probation division, a detention division, and a programs division. We'll be talking mostly about probation and detention today. We also have the Bridge, which is a new youth and family resource center. We just had the ribbon cutting on Monday. That is a best practice, thank you, that we're initiating here in Ada County, and we'll talk to you a little bit about that because we'd love it if you sent us kids. We're going to cover the Juvenile Corrections Act, how kids come into the juvenile system, the case flow in juvenile court. As we go through, we'll be talking about differences between juvenile court, what's different here, what to expect if your child or a youth that you know of is in the juvenile system, and then some best practices and new initiatives. So first of all, who's a juvenile? This is a definition from Idaho Code from the Juvenile Corrections Act. Juvenile means a person less than 18 years of age or who was less than 18 years of age at the time of any alleged act, omission, or status. The words youth or child may also be used. So if a almost 18-year-old, but still 17 and 300 days, commits an offense, that offense would stay in the juvenile system even when that person turns 18. Juvenile Corrections Act. A juvenile can be subject to the jurisdiction of the juvenile court for committing an offense that would be a crime, so a misdemeanor or a felony, if they were an adult, or for committing a status offense. So what's a status offense? It's an action that's prohibited only because of a person's age. What we often see in the juvenile system is runaway and juvenile beyond control. So we will get calls from parents reporting their children to the police for being, quote unquote, beyond control of the house rules or beyond control of their parents, or for running away. The Juvenile Corrections Act does not apply to violations of beer, wine, alcohol, or tobacco laws. We'll talk about that a little bit as we go through, but those are handled in quote unquote regular court, so the system that you've heard about today, downtown, the big courthouse down here. So for instance, from Monica's point of view, it would be the public defenders, misdemeanor public defenders down in her main office, not the juvenile public defenders. It is the policy of the state of Idaho that the juvenile corrections system will be based on the following principles: accountability, community protection, and competency development. Where a juvenile has been found to be within the purview of the Juvenile Corrections Act, so instead of finding juveniles guilty, they're found to be within the purview of the act. The court shall impose a sentence that will protect the community, hold the juvenile offender accountable for his actions, and assist the juvenile offender in developing skills to become a contributing member of a diverse community. Because that's what we want. Kids, we all made mistakes as kids. Kids make mistakes all the time. We want them to grow up and be contributing members of society. We don't want anything that happens to them as a youth or an adolescent to ensure that they won't be able to do that. So what's different here? Parent involvement in juvenile court. We get a lot of parents who think once they've decided their child is difficult, we should take the child, punish the child. Jessica should take the child to detention, punish the child. We should fix the child. Nope. It's very important and in fact required that parents take part in programming, parents take part in the process. A judge can in fact require parents not only to pay fees for court cost probation, supervision, detention, community service, or other programs, but also, and also pay restitution, but to participate in the process. They can require not only that parents get their children to counseling, but that the parents take part in counseling or other programs from time to time. What else is different? Skill development. Juvenile court is less about punishment and more about developing skills, competencies for youth. We want youth to gain knowledge, learn new skills, and make restitution if appropriate so they can, again, become productive members of society. So it's more of a helping approach. And Lael will talk more about that. Basic case flow in the system. An offense is committed. Monica, you'll appreciate that I said a suspected offense is committed. So maybe they did something, maybe they were reported for doing something, maybe their parents just called them in because they're troublesome. Something happens. Law enforcement is called, and they can either release the youth to the parents, perhaps they give them a warning, or they say, we don't want to come back here tonight, or they can take the youth to detention. A third option is writing a police report and sending it to the juvenile prosecutor's office for review. Once the system, the youth is in the system, there's an admit-deny hearing. That's similar to the arraignment or the first appearance downtown or a detention hearing. Pretrial conference, much the same. Evidentiary hearing is like your jury trial or your court trial downtown. If that's needed, a sentencing hearing. Contact with law enforcement. I'll do this one and then turn it over to you. Okay. So again, law enforcement can do a couple of things. They have a lot of discretion with regard to youth in particular. They can warn the youth, they can take the youth into custody, or refer the case to the prosecutor's office for review. They can also refer the youth and family to other programs, and we'll be talking about our Bridge program at the end of the presentation.
Okay, so if the youth is taken to the detention facility, what's going to happen is the prosecutor's office is going to screen the report that law enforcement forwards to them to determine if they're going to petition the case. If they petition the case, then a detention hearing will be held within 24 hours, or kind of the same case as the adult jail. We don't want to see youth coming in on a Friday because they're going to be there until Monday, or if it's a holiday, Tuesday, when they're going to see a judge. And then at that point, the judge is going to decide if the youth is going to be held or released. If they're held in detention, they're going to set another court date, and they're also going to set another court date if they're released to their parent, guardian, to a program, whatever the release may look like. If a youth is released, they can be put on an order of release, which means there's going to be terms that the court has expectations for their release. A probation officer will assign on an order of release, or they can just be released on their own recognizance with no terms attached to it. Once a youth arrives in detention, what's it going to look like? Our staff, our detention officers, we don't want youth in detention that don't have to be in detention, but our detention officers are amazing working with the youth when they do come into the facility. What we're going to do is we're going to try and separate them from the law enforcement officer, the arresting officer, as quickly as we possibly can, and start working with them to get as much information as we possibly can to understand a little bit more about their risk to be a victim while they're in our detention facility, any of their immediate behavioral health needs that they might have, any medical needs that they might have. We don't have as many medical services and psychiatric services as a jail has. We have a RN, and we have medical assistants that are on staff for 7 days a week, about 12 hours a day. What we often will have is if law enforcement are bringing youth in under the influence, or if we suspect they might have been in an accident, we will ask if they're medically cleared at the hospital prior to taking them into detention. Excuse me. We also have a medical or a mental health screen that we'll put you through, so we know where to house them in our facility, what kind of supervision we're going to put them under, what kind of checks we're going to have on them. In detention, what we do have also, we have access to school services. Boise School District provides educational services. We have religious services. We have contact visits and phone calls with parents, and our licensed clinicians are also going to provide services. Okay, so what does it look like? So police have contact with the youth. They're going to send it to the prosecutor's office. If the prosecutor's going to screen, the prosecutor could decide not to accept the report, and if it is, they decline. It could go to the diversion program or to formal petition.
Thank you. So at this point, if the prosecutor makes the choice to send the police report to the diversion program, that falls underneath probation. It is an opportunity for the youth to expedite their case in some regard because the court is not involved. Sorry, I'm not sure. Oops. I'm new. Bear with me. Okay. And so through the diversion program, interpreter services can be accessed at any point. A probation officer is assigned, but they work in the capacity of a diversion. And they're kind of a team with the youth and the parent to work on what's going to best address the behavior that came in the police report. Advantages to diversion is there's no judge, there's no court, there's no detention. It's a faster process. We do follow best practices, and we're building on strengths. We recognize that most adolescents are self-correcting behaviors at that stage. And so we're building on strengths, keeping them in the community. In Ada County, we supervise about 500 a year through the diversion program, and we have a success rate. It's climbing. We're getting better each year. Average is about 88, but we saw a 92% success rate last year. Once a diversion case is closed successfully, the youth has the opportunity to have a clean criminal record because there was never any court involvement or detention center. So we operate off a police report, no legal documents. If diversion isn't selected and it's going through the formal court process, this is what it looks like. The petition goes through the flow of the process, starting with the admit-deny hearing. If the youth went to detention first with the petition, then their admit-deny hearing would be at the detention hearing. And that's when the public defender can become involved, interpreters can be used. The court communicates. If the court knows the interpreter is needed first, the clerk's office helps bring the interpreter. If detention knows, if probation knows, all of us are working together to make sure language access is happening. If the youth admits the charge at their admit-deny hearing, then it moves towards sentencing. If they deny, it goes through the pretrial conference. That's also with the assistance of the attorney. If it's resolved at that point, it then goes to sentencing or a disposition hearing. If the charges aren't resolved at pretrial conference, it can then go into evidentiary hearing. Evidentiary hearing in juvenile court, it's similar, as Allison said, as trial, but we don't have juries in juvenile court. It's the judge who's going to listen to the case and determine whether or not the youth committed the crime. The judge is also, if and when the youth goes to sentencing, the judge is going to determine what that sentencing looks like. Excuse me. So the judge is going to determine the length of probation as well as the type of probation. Probation officers, regardless of what the type of probation is, anyone within the probation division will supervise them. The judge is also going to take into consideration, sorry, I don't know. Had a lot of bullets. The judge is going to take into consideration the crime, the youth's age, the youth's family situation, school situation. Also going to take into consideration any drug and alcohol issues, mental health issues, the impact on the victim, the support services. So at a juvenile hearing, all of those things are taken into consideration, and that information is provided to the court through the probation officer. youth who have repeat offenses or very serious offenses, the court does have the discretion to commit them to the Department of Juvenile Correction. A small percentage of our youth do get committed, but it is a process through juvenile court. Once a probation officer comes involved, we become involved at the very beginning of a stage, but we don't supervise the probation until the court has put the youth on probation. In Ada County, our role is to assist the youth and family through the entire process, and we follow best practices in doing that, and we're seeing better outcomes. We've moved away from compliance and violations and working with graduated responses. So everyone on probation, all the probation officers are trained in all of the evidence-based best practices, and the goal behind this is supporting youth and family with the different approaches for successful completion of probation.
Where's Jessica? Officer Nar has suggested that if we go a couple minutes over, that's okay because we're last and we had the whole system to get through. But we'll go quickly. So are there alternatives to formal processing in the juvenile justice system? That's what we want to talk about quickly. So we often hear from parents sometimes that they want to bring their kids to detention, that they want to tour detention to scare their kids, that we need to admit more kids into detention to change their attitude. Is that accurate? We know, all of the studies tell us that detention does not scare youth straight. It does not reduce the youth crime rate. It doesn't deter specific youth from crime. So a particular kid doesn't think, using that wonderful adolescent brain, they don't say, oh, if I do this really stupid thing right now, I could go to detention, so I won't do it. Nope, they do it anyway. And it does not deter other youth from crime. They don't say, my friend went to detention because he did that, so I'm not gonna do it. No, they do it anyway. What does detention do? It causes peer contagion, so more delinquent youth influence less delinquent youth. We have some kids in our detention center right now that absolutely need to be in there. And I know there's some law enforcement here. We had a youth that came in Friday or Saturday. We were really, really happy that law enforcement brought him in. He needs to be in our detention facility so that we can protect the community right now from the choices that he's making. But when we introduce less criminal youth that are simply quote unquote beyond control, running away, doing much less serious offenses, we will turn them into criminals because they'll hang out. They're so subject to peer pressure, they're gonna learn from the more criminal youth. It also decreases the likelihood of high school graduation. It increases the likelihood of incarceration as an adult. It increases recidivism rates. Pretrial detention increases the odds of felony recidivism reoffense by 33%. Brand new study tells us that. It impedes later success in the labor market and it increases their risk of self-harm. We also know that formal processing in general doesn't necessarily result in better outcomes. We've often heard that we need to get kids into the system to get them help. That does not turn out to be the case. Again, 2021 study that tracked a couple thousand boys shows that youth who were formally processed as opposed to being diverted in the community were more likely to be rearrested, more likely to be incarcerated, reported more exposure to violence, lower rates of school enrollment, less ability to suppress aggression, and lower odds of graduating from high school. That's not what we want to see for the youth in our community. So what are some things we can do? Youth and family resource centers or assessment centers are a best practice. The National Assessment Center Association established a framework based on research and best practice. There are 80 throughout the United States. They have been shown to save law enforcement time, increase coordination among agencies working with youth, and speed up the process of getting help for kids and families. So Monday, we had a ribbon cutting for The Bridge. It is a youth and family resource center here in Ada County. It's located right across the street from our court facility. We are following the National Assessment Center Association protocol very closely. We actually started taking kids in March. We're seeing some really good results. We're still learning. We're gonna be really carefully watching our data so that we can compare kids who went to the Bridge with kids on statutory diversion, kids that were formally processed. There are materials on your tables with some information about the Youth Resource Center, which is the Bridge, and the Youth Crisis Center, which we're going to talk about. If this website comes up, if you put in the Bridge Ada County, law enforcement can bring us or refer kids to us, schools can, any of you can, and parents can self-refer. So now if a parent calls detention or drops in on Jessica's staff and says, you know, I need some help, can you take this, you know, boy back and show him detention? We say, we don't do that, but here we have someone you can meet with. We're getting kids in very quickly as well. So we're more timely, able to offer more timely assistance to the family. Also, I'll get here in a second, the whole family is assessed, so the process is really interesting. We bring the youth who's being referred, siblings and parents in. We do validated screening and assessment tools, and we're offering resources to the entire family, including some parenting classes we'll be offering for free right at the center, referrals to counseling, peer activities, all sorts of other things. So we're very excited about the potential that we have to do better work with our youth here in Ada County. Additional good news, and this is on the flip side of the brochure that I put on your tables, a youth crisis center is opening in Ada County October 15th. One of the presentations talked about Pathways Adult Crisis Center. When they talked about CIT, this is the same thing, also run by Pathways for youth. It's free of charge. They won't turn anyone away. It will be located off Emerald. The location's on there, very close to the Boise Police Department. They also got a grant, as we did, to start our centers. They'll include a 24-hour crisis hotline, medical screening, assessments, crisis intervention services. They actually have 12 beds in the facility and are hoping to take more. And then they will provide community-based referrals for those youth, which may include stepping them down to our resource center. So we'll be working very closely with them. But we think the combination of these two facilities is going to really change outcomes for youth and families here in Ada County. So please ask us if you have questions on that. This slide shows our website. There is a document there in the middle, understanding how the juvenile justice system works in Idaho. Too much information to discuss today, but if you get a youth or family who needs more information about the system, that's in Spanish and in English. And then our Bridge Youth and Family Resource Center has frequently asked questions and a referral form. You can just start typing, how can we help you today? You can call us, you can refer a youth and family to us, and we will make contact with them. We'll reach out to them and get them in so that we can hopefully help them. Can you think of anything else? All right. Are there any questions?
So how much do you guys work with parents, specifically non-English speaking parents, to make sure that they know everything that that needs to happen with the child and what the child needs to accomplish to get out of this?
Great question. So when we're working with, sometimes youth have easier time understanding English than the parents do, but interpreters are available for the youth and parent, and if we need two interpreters because there's two different meetings, we'll also make that. But probation meetings, so not just the court-involved meetings, but any probation meetings, we also bring in interpreters, and we have a great staff that's willing to slow down the pace, explain the process, talk about different phases they work through. Family engagement's important to us, and we understand parents need to know what's going on just as much as the youth do.
I think my question pretty much follows up what JJ said. I just want to clarify, during the court trial process, when it's open court and the judge is speaking to the juvenile, if they're receiving interpreter services, is there a separate interpreter allowed for the family, or is it the same interpreter and the parents get to sit with the child? What does that look like for the families of the youth in the process?
During the court hearing, if it's the same language, it would be the one interpreter, and I don't know if you've been in our courtrooms, they're pretty small, and the interpreter would sit with the family but also assist the youth.
I feel like I should know this, but when you guys have a juvenile that is sentenced to the jail because it's on an extreme charge. Do you guys still provide services? Because I know we sometimes in the programs bring in the Boise public or the education system and stuff like that for those individuals who are sentenced to jail at the Ada County Jail as an adult, sentenced as an adult.
So as of last year, the presumption has changed that previously youth who were charged with an adult crime would go to the jail, and then it would have to be petitioned that they would return back to the juvenile detention facility. That changed recently, so now they stay with us unless it's petitioned for them to go to the adult jail. It is a better place for them in the juvenile facility. When they go to the adult facility, they have to be isolated. They do not have access to services. They do not have access to education. So we really believe that it is the best place for youth.
You're talking about under 18. So not kids that are, because we do get 18-year-olds that are still in the juvenile system, and we actually have a meeting coming up to talk about how if they're not on a detention release order, but they're still supervised by our folks, how we can work better with your pretrial release folks.
Are you going to do it for alternatives too? Because I know you guys juveniles are sentenced to like our CTC, community service, SEAL, that kind of stuff.
So the first meeting is mostly on the pretrial release. It's with the judges coming up, but that's a really good point, and we will bring it into that conversation. So I appreciate that. Thank you.
Thank you, ladies, very much.
Thanks, everyone.